Oops. Yeah, very change. Tatna doesn't want to be responsible for my screw ups. She's done enough of that already.
All right, let's go ahead and let our participants in. Okay, I think we are good to go. Good afternoon, everyone, and thank you all for joining us for today's A Month of Service presentation of evictions and knowing your rights. My name is Nia Murray. I am the programs coordinator with Neighborhood Recovery Community Development Corporation, and we are one of the partners in the A Month of Service collaboration. Also included is the City of Houston's Department of Neighborhoods, and joining us today, we have Ms. Cecile Carlson. Also, on behalf of our presenting partner with Lone Star Legal Aid, we have Mr. Benjamin Daly, who's going to be providing you all with the information about evictions and knowing your rights. Also included in our partnership, however, we do have the Texas Legal Services Center, uh, um, Houston Volunteer Lawyers, the Earl Carl Institute, Harris Central Appraisal District, and the Harris County Tax Assessor Collector's Office. And together we make up a month of service. And for those who are not aware or not familiar with a month of service, a month of service is the collaboration of all of our organizations coming together on a monthly basis, offering a variety of different workshops, resources, and information to the community relative to community empowerment, asset building, asset protection, and the maintaining of generational wealth. We know that there are a lot of underserved communities that are out there, a lot of folks that don't know where to go for particular resources or for accurate and the most up-to-date information, where they can actually call on people and and get information that they need that would help with their particular issues that they have. So we decided to collaborate several years ago and pool a lot of our initiatives together and all of our programs so that we can create a larger impact and reach more people, and get as much information out to the community as we possibly can. So we used to be in person when we were doing these presentations previously, and we will slowly but surely get back into our routine of being able to meet people in person. However, we are trying to do a couple of hybrid meetings just to kind of ease our way back into to doing that. But over the last several years, we have been able to expand our program, our offerings, our collaboration into including more presentations based on the feedback that we do receive from the community. Um, so at the end of this presentation, there will be a quick link. If you guys could just take a moment to fill out the survey from that link, just to kind of give us your feedback to make sure that you're actually getting the information that you intended when you registered to attend today. If there are other questions that you may have, or if there are other issues, topics that you would like for us to present about that we don't currently offer, then we would love to have your feedback, and just let us know so that we'll know as we're planning future presentations, we'll know what to provide for you. So also know that this is your opportunity to ask whatever questions that you may have of the professional that is here. This Benjamin is a staff attorney with Lone Star Legal Aid. However, we are on a public platform. We do ask that you try to keep your questions to be as general in nature as you possibly can, so that you don't divulge any personal detail information about your particular situation. We don't want, I'm a resident at such and such apartment, and the property manager's name is yada yada yada. I live at here. We don't want you to do all that. We want to try to protect your privacy as best as we possibly can. So do keep that in mind. However, again, this is your opportunity to ask those questions. You can feel free to type your question into the chat, and we'll review the questions at the end of the presentation, or you can unmute yourself and raise your hand, and just ask directly if you don't want to type. We do record the session and send out the link of the recording for those to go back to review the presentation again, or to share with other folks that may need this information and find it to be beneficial as well. We also do broadcast on our social media platform. So again, we want to try to best protect your privacy as we can. So do keep that in mind. But if you are joining us on social media, then we do invite you to type whatever questions that you may have in the comment section, and then you'll be able to. I'm monitoring that, so I'll be able to ask your questions to the presenter from there as well. So know that we'll try to get to everybody's question as best we possibly can. So with that being said, there's quite a bit of information that's going to be covered here today, and we want to thank you all for joining us. And I hope again that you received the information that you came to get here today. So, without further ado, we are going to start with our introductions, and then we'll move right on into our presentation. So, Ms. Cecile, would you like to introduce yourself first?
Sure thing. Thank you, Nia. Good afternoon, everybody. My name is Cecile Carlson. I'm an outreach coordinator with the Department of Neighborhoods, and we are one of the partners in a month of service. We're very thankful for everybody that's here today, and also very thankful for our presenting partners. Lots of great and useful information directly from the experts. So like Nia said, make sure that you ask questions and you get all the information that you need. Contact information will be shared as well at the end of the presentation. And I'll go ahead and pass it on to our presenters. Again, thank you so much for being here.
Right. Benjamin, go right ahead. I did want to say I did forget to give the disclaimer. Information that we do provide here is for educational purposes only. It is not to be considered legal advice. However, we do encourage you all, if you are in need of any civil legal assistance, to reach out to our legal service partners for their services. All right, go right ahead, Benjamin.
Okay, everyone can see the PowerPoint?
Yep, you're good to go.
Okay. Hi, my name is Benjamin Daly. I'm an attorney with Lone Star Legal Aid, and this is Evictions, Know Your Rights. Before I get started today, I always have to give special acknowledgement to my colleague Kim DK, who created this presentation. Before I get started too, let me talk a little bit about my firm. Lone Star Legal Aid is a 501c3 nonprofit law firm. Our main goal is to represent low-income individuals in a variety of civil legal matters. We have specialized units, like our eviction unit, but we also provide general units for specific populations, such as our veterans unit. And we can provide everything from simple advice to full representation. I'm happy to give you information on how to apply at the end if you need additional assistance. So our agenda for today, we're going to be providing some general information about what to expect in some basic landlord-tenant cases, most specifically eviction, but we'll also cover some different sorts of suits, such as suits to restore utilities and writs of reentry. It's important to note that this information is all general. Most cases are going to turn on case-specific facts. So just be aware, if you need additional assistance, or you need to ask questions specific to your case, you're going to want to speak to an attorney or apply for our services. As always, if you're confused for any reason, you can always ask for help. Special disclaimer, generally speaking, because we're also going to be talking about not only defensive suits for the tenant, but also suits a tenant might bring, it's a good idea to speak to a lawyer before filing any lawsuit. Finally, this information is going to be current through the end of the year. We did have the legislature pass a new bill that changes the eviction process in some ways. Some of them are small, some are very significant. And so if you're watching this in 2026, you might want to find a newer presentation. We're not going to be talking about the new law today. There are still some things that need to be developed, such as new rules of civil procedure. And until those are presented and approved, any information we'd give today on that would be incomplete and potentially subject to change. So, keep looking for these presentations. I'm sure we'll do one before the end of the year, going over what the new law says and what to expect, but that's not what we're doing today. So time to get into the meat of the presentation. So the first thing, leases. A lease is an agreement between a landlord and a tenant that basically establishes the tenant's right to possess property that is owned by the landlord. Texas allows for both oral and written leases. If you have an oral lease, you're going to want to take steps to document the terms of the lease. And you should note that any lease term that has a term for longer than a year needs to be in writing. leases are extremely important because leases are going to control in most disputes. The property code provides standard rules, but some of these rules can be changed if the lease provides for it. So, for instance, we'll talk about notices to vacate timelines. The code allows for one timeline to provide in a notice to vacate, but that timeline can be altered by the lease. So you want to make sure you have a copy of the lease and you want to make sure you review the lease. Every tenant has a right to a copy of the lease within 3 days of being signed by the parties. If you did not receive a copy of the lease, you want to ask for it in writing. The code does provide for a cause of action that can be brought if a landlord refuses to provide a tenant a copy of a written lease. Some basic things that you're going to see in lease terms. Obviously, the lease is going to provide what the monthly rent is. It's going to tell you, in many cases, where and when to make payments. It may provide for late fees, and it is going to say how payments are applied. And that third point is fairly significant because a landlord can take rent payments and apply them to other fees or other costs if it's provided for under the lease. It's also going to provide an initial lease term. We generally see two types. One is a set term, such as a term for a year. The other are month-to-month leases, where you just have a lease that goes for a month and just automatically renews. Even leases that go on for a year often contain language that will automatically renew an expired lease month to month with the same sorts of rules or perhaps with a penalty if it goes to month. But just be aware that, at the end of a lease term, if something new isn't signed, there may be provisions that roll the terms over to the next month. Oftentimes, leases are going to include language incorporating community rules and lease addendums. What that does is, first of all, it allows them basically to provide you the information as far as what the rules are or as far as how the property is going to handle different things, such as utilities. But the other thing it does is it means that a violation of community rules or violation of those lease addendums constitutes a violation of the lease. And that's important because if the landlord is looking to move forward on sort of a eviction for breach of the lease, they can rely on those addendums if they're incorporated into the lease. Keep in note too, those addendums sometimes conflict with the lease. So for instance, if you're talking about public housing, the public housing addendums may contain language that significantly alters the terms of the original lease. Usually those addendums will contain language as to how to construe interpreting those addendums when they're in conflict with the original lease. Lease should define what an act of default is. Defaults include things like failing to pay the rent. It could be something like breaching the lease or violating community rules. Or it could provide information about sort of when a party can decide to terminate the lease early or what happens if a party holds over after the lease ends. Finally, a lease, like I said, can include information about timelines, such as when notices need to be given. Those timelines can be altered by the lease, so it's very important that you review it before you're dealing with any of these issues that we're going to talk about today. So terminations come in sort of two varieties. One can happen at the end of a lease term. So this is you have a lease for a year. At the end of the year, the landlord, for whatever reason, decides they don't want to offer a new lease or new extension. The other type of termination that could happen is a termination that happens early due to a breach of the lease, or it could happen for a different reason. We'll talk a little bit about that in the next couple of slides. Keep in mind that a termination of the lease requires written notice. You can't do this orally. At the end of an original lease term, statutes generally provide a 30-day notice requirement to terminate the month-to-month lease. Keep in mind, though, those timelines could be altered by the actual terms of the lease. So you want to review the lease instead of simply relying on the code. So we're going to talk a bit about some instances in which a tenant might have a right to terminate the lease early. Um, these are all provided for by the statute. Some of these can be waived, some of these can't be waived. Some of these, if the landlord refuses to allow the termination, there could be a cause of action that could be triggered. The code is going to spell out in detail how each of these sections function, what sort of notice is required, who's actually covered by these rights. So it's important before moving forward on early termination that you actually read the statutes themselves. And it's probably a good idea to get an attorney's opinion if you believe that you have a right that's not being recognized by the landlord. So some instances, if you're a victim of family violence, if you're in sex offenses or stalking, you know, you can trigger early termination if you're the tenant. Those cannot be waived by the lease. If a tenant dies while residing on the property, you can terminate the lease to avoid future liability, although past obligations are still recoverable by the landlord. Notice the lease is not required for that. And then there are certain military determinations. So, for instance, if you're an active duty service member and you have to terminate your lease early because you're put on active duty, you might have the right to terminate that lease early, although that can be waived under the lease in certain circumstances. The one we really want to talk about in a little bit more depth is one that unfortunately we see far too often, which is casualty loss. Casualty loss, in layman's terms, is basically any sort of damage to the property due to some form of disaster. So you're talking about fire or flooding or hurricane winds. Any of those could potentially cause casualty loss. Uh, and it could open the door to either party terminating. The key thing to remember is that whether you have a right to terminate possession or the lease really determines on, it's really premised on whether or not the premises are totally unusable for residential purposes. That's a fact question. So I won't get into what that basically means, but if basically you cannot use the property as a residence, then either party can terminate the lease. If the resident has been, sorry, if the residence has been damaged, but you can still use parts of it for a residence, then you do not have the right to terminate the lease. Keep in mind too, this is another area where those rights may be waived or altered by the lease. So you want to review the code, you want to review the lease if you're dealing with an instance like this. Now we come to sort of the main focus of today's presentation, which is what happens when you're dealing with an eviction due to a breach of the lease. So as discussed, breach of lease is a violation of lease terms. It's going to be spelled out in most cases in the lease itself. And it's going to be defined. If the lease incorporates community rules or addendums, keep in mind violation of those rules could be a violation of the lease. And keep in mind too that lease rules can be written in a way which gives a landlord broad discretion to label behavior a breach of the lease. So one thing that we see often are people who are being evicted for being discourteous and disrespectful to staff. So you want to review your lease, review the community terms, sort of understand that in a lot of cases, sorry, give me one moment. My apologies. So you want to be aware of basically what the rules are that you're operating under. Some common defaults that we see: failure to pay rent under the lease by the date stated, violation of those community rules and policies if they're incorporated into the agreement, having unauthorized tenants, criminal activity happening either on the property or near the property, or holding over after the lease has been terminated. Keep in mind, if the breach of lease occurs In order to terminate, the landlord does need to provide proper notice before filing an eviction. And we'll talk about sort of the notice to vacate that might be issued as part of that in a moment. Just to go over some special cases that we unfortunately see. This is unfortunately a common fact pattern due to some information online that's not totally accurate. We might see people who, instead of paying their rent, decide to withhold their rent due to a landlord not making repairs to the property. There are some states in which that's legal. That's not the case in Texas. Texas requires that rent be paid in full and on time as it comes due. It's also fairly safe to assume that withholding rent is a breach of the lease. In addition to opening you up for an eviction, withholding rent also is counterproductive in terms of getting relief on the issues that you're seeking to remedy. Texas law requires that rent be paid in full and on time. It requires that the rent be paid in order to have rights to the repairs or remedies as well. Once you fall behind, your landlord does not have to fix your apartment. Repair remedy claims also can't be brought in an eviction suit. An eviction is specific only to dealing with possession of the property. You can't raise other issues. If you do have issues with repair and remedy, and you are entitled, the first thing you want to do, rather than holding rent, is to send a written request, basically demanding that repairs be made. We recommend sending this via certified mail because the code allows that process to go quicker. It also allows you to track when the landlord receives that notice. Code requires that you wait a reasonable amount of time before filing a lawsuit. Reasonable time is usually presumed to be about 10 days. So, it is a process, but there are clear rules on how to do it. As always, we recommend that if you're dealing with those issues and you are thinking about filing a lawsuit, speaking with a lawyer to get advice rather than filing it on your own. The other special case that we see is what happens when rent, which is properly tendered, in full and on time, is refused by the landlord. Landlord is not free to refuse properly tendered rent pursuant to the lease agreement, but they may refuse rent if it is late, if it's a partial payment, or if the lease itself has been terminated. The landlord also can determine the manner in which amounts are paid. So if the lease says that you're supposed to pay online using their portal and you decide to try and pay via money order, they might refuse it because it's not tendered the correct way. If you are in a position where your landlord is refusing rent, there are a number of steps you need to take. The first thing, you want to review your lease and a current ledger to make sure the amount you're offering is covering all rent and all fees, and to make sure the payments offered and are consistent with the lease. You should also make sure that the lease agreement itself has not been terminated. So for instance, if the landlord says, you're giving a notice to vacate because you were rude to staff and you try to make rental payments and they refuse it, you want to document the payments were made, but you can understand that, they might be able to refuse that rent. You want to document the date and the manner of payment. You want to make sure you're documenting correspondence you have with your landlord. So you want to try to communicate with them so that it's clear that not only you're tendering the rent, but that they know you're tendering the rent. It's important to keep the payment or the funds that you were going to tender available for future payment. Just because your landlord refuses rent 1 month doesn't mean that they might not demand payment the next month. And it's a lot cleaner to have those payments available than to spend them elsewhere and to deal with a deficit later. You want to continue to offer rent in full and on time for future months. And finally, this is an instance in which if you're dealing with this and you think your landlord is refusing rent because they're looking to evict you, contacting an attorney to seek additional advice and assistance. Couple final notes. Make sure that you're always tendering rent, even if the landlord has refused rent in the past, or even if they verbally state that rent will be refused. If you have it documented that you're providing the rent timely, and you have documentation the landlord refused it, that could be a defense if the landlord files a non-payment of rent eviction. But if you claim the landlord told you they weren't going to accept it and they dispute that in court and you don't have the documentation, that could create problems. Finally, if there's a dispute over the proper amount to be paid, it's better to try to tender the higher amount and then potentially bring a lawsuit against them to try and clarify the amount owed later than to tender the lower amount, have it refused, and then wind up with a non-payment of rent eviction potentially pending. Having done a lot of these, and I mean a lot of these sorts of cases, it's a lot better to be on the offense than the defense if you're a tenant. So just, do what you can, to document things and do what you can to try and make complete payments and then clean stuff up on the back end if necessary. So, sort of back to the termination notice. When you're dealing with an eviction for a breach of the lease, this process really begins with the notice to vacate itself. Notice to vacate is required by the property code. The property code requires that a 3-day notice be given unless there's a lease that provides for a shorter or longer period. And there's also federal law which may require longer periods. So just be aware, 3-day notice is standard. Most landlords will use it, but you want to review your lease to see if there's a shorter amount. And then there are instances in which be entitled to a longer amount. The notice must be in writing and it must contain language demanding possession of the property. That's very important. If you get a notice that just says, hey, you're behind on rent and doesn't demand possession, that's not a notice to vacate. And that can't be used to evict you. The code also provides information about how to deliver a notice properly. There are only a few ways in which you can do that right now. The first way is it can be hand delivered to the tenant. So in other words, landlord knocks on the door, tenant opens it, landlord hands the tenant the notice. Second, the landlord can mail the notice to the tenant at the premises. And the third is that the landlord could post the notice on the inside of the front door. So in other words, they go to the property, they unlock the door, they open the door, they post it on the inside, close the door. Notice is in the unit now. Generally speaking, the landlord is not allowed to post the notice on the outside of the door. There are specific instances in which they can, if there's some reason they can't access the property itself. There are very specific rules about how they have to do that, though. So first of all, the notice has to be in an envelope, has to be placed on the outside of the door. It has to contain some writing, basically identifying the person, stating you have important documents in the envelope. The landlord has to then mail a copy of the notice to the tenant by 5 o'clock the same day. Landlord has to show in court that they've done all that and prove up that they elected to post this on the outside of the door because they couldn't access the unit for what the code shows as a number of reasons. Right now, and granted this might change at the end of the year, but right now, documentation of how the notice is delivered is extraordinarily important. If you come home and you see there's an envelope on the outside of your door, you should take a picture of it before taking it down or opening the envelope. The reason for that is that if the notice is improperly delivered, then the eviction has to be dismissed. The landlord cannot move forward. But if you don't document how it's delivered, it becomes a question of testimony and credibility. And trust me, you want the documentation. As I mentioned, there are some instances in which a tenant under federal law might be entitled to a longer notice period than the 3 days. In this case, the CARES Act requires a 30-day notice for tenants residing either in, residing in covered properties, which is either a property covered by VAWA, a property covered by some program that provides federal funding, or property which accepts federal program funds. So public housing, such as Section 8, Housing Choice Voucher, rapid rehousing, if the property's low-income housing tax credit. Residents in those properties were required to get 30-day notices. And finally, if the property has a federally backed mortgage, such as through Fannie Mae, Freddie Mac, FHA, or VA, those residents are required to get a 30-day notice. Keep in mind, for federally backed mortgages, that can include single-family homes, duplexes, mobile homes, anything that might take those programs money, or have a federally backed mortgage. For larger properties, you might be able to find information on this, whether your property is covered by CARES Act or not, using some databases. We should note, though, not all databases are up to date. The best way of looking for this information is to check the real property records. Additionally, our position is that the CARES Act is good law. There have been some challenges, and although the vast majority of case law says that this act is still in effect and still good law, we recommend, if you think you have a CARES Act property, going to talk to a lawyer, both for the reason of needing the property records information in order to prove up that's covered property in the CARES Act, but also to argue against any challenges to the validity of the law. Now we come to the fun part for me, probably not so fun for the people actually going through the process, which is the eviction trial itself. So a lot of people don't understand this, but an eviction's primary focus is to deal with the right of possession of the property. The code is very, very specific about this. You can't just litigate grievances either against the landlord or the tenant in these. There's no counterclaims. You can't add on separate causes of action, with the exception of a suit for rent. The main question is, who has the right to possess the property? The main elements that the landlord must prove: they have to show ownership of the property. They have to show that there was a lease agreement, that that lease was breached. They have to show that they gave proper notice under the code. They also have to show the defendant did not leave before the expiration date on the notice to vacate. Important to note, when these suits are filed is actually pretty important as well. I've seen a lot of lawsuits lately where the landlord has provided a notice to vacate, which provides a specific date as to when the tenant's supposed to leave, and they file the suit the day of the deadline, when the proper way of filing is to file the day after the deadline. And so those lawsuits have to be dismissed. So if you're facing something like this, pay attention to those timelines. As I mentioned, in non-payment of rent suits, the only thing that can be added to one of those lawsuits is a claim for back rent amounts. Landlord can only ask for the back rent, though. They can't ask for utility costs, late fees, any other fees. They could get court costs, and if applicable, they could get attorney's fees, though. Before we move on, we often get questions about jury trials. You do have a right to request a jury. At the JP level, jury demand must be filed 3 days prior to trial, and all the fees associated with the trial must be paid or waived. If you don't pay the amounts for the jury trial, or if you don't file that demand timely, you waive your right to a jury. If you do apply for a jury, but you're denied the right to a jury for whatever reason, we recommend speaking to a lawyer. There may be some rights there that have been violated, and an attorney should look at that. So all evictions start in justice court. Justice court is meant to be basically a court open to anyone to allow them to have sort of really basic lawsuits heard without the need for specific legal knowledge. For that reason, they use simplified procedural rules. They don't have to follow the rules of evidence. And for those reasons, they actually can differ in how they're run fairly significantly from court to court. Here in Harris County, we have 16 different justice courts across 8 precincts. And even within those precincts, the way the two courts work could be dramatically different. So just be aware of that. If you have dealt with a lawsuit in the past in a different location, you get sued in a different court, your experiences there could differ dramatically. Our recommendation, if you're facing trial in justice court, once you get notice and once you get your date, show up early to court and have everything that you need for trial. The reason you want to show up early is some courts have community groups that provide assistance or resources. Some courts want you to confer with the opposing party before trial. And it hedges against Houston traffic. So, you want to make sure that you're there for court, preferably early, and that you take advantage to everything the court might offer. When you arrive, you're going to want to check in. Some courts do that where they have people check in individually. Some will direct you to sit down and they'll do sort of a mass docket call where they'll just read through the cases and you simply announce your presence when they're doing that. If you have any questions on how that works, you want to talk to the clerks, they'll give you the instructions on what to do. Before trial, there are some judges who will get up on the bench and give instructions on how the court works prior to calling cases. It's usually a good idea to listen to what they're saying, just so you have a sense of how things might run. When the case itself actually is called, you get called up to the front. Judges are going to begin by hearing the plaintiff's case first. Then they'll give a defendant an opportunity to respond. They may ask if you have questions for the plaintiff if you're the defendant before putting on your case, or they may simply allow you to put on your case. It largely depends on the judge. Make sure that if you're there, you're listening to, what the parties are saying, and that you're prepared to answer judges' questions and provide the evidence either in favor of your case or against the case, the other side. So just, come prepared. We often get questions about seeking continuances or resets. Trial generally can only be reset on motion of the plaintiff or if both parties agree to the continuance. So there's not the procedure that allows a defendant to simply beg for more time from the court. At the end of trial, the judge is going to issue a judgment in favor of one party or dismiss the case. You want to make sure you're getting a copy of the judgment for your review into your files. As a sort of a general note, this process is stressful for everyone. The best thing you can do for your case is to be respectful to the judge, to the court staff, and to the opposing party. One additional thing that we wanted to mention is not on the slide. We do sometimes get questions about needing special accommodations, such as a Zoom hearing. Our recommendation is you want to communicate with the clerks early and see what the court needs. So, for instance, there are some courts that will allow you to appear on Zoom without making a motion. There are some courts that they want you to make the motion, but they're generally pretty permissive about letting people appear remotely. And then there are some courts that are going to want to see good cause to allow you to appear remotely. So the best thing to do would be to talk to the clerks first and find out, what they need from you. Real briefly, as I mentioned, as part of this process, judges often require that the parties speak prior to coming before the court. And if they don't, it's usually a good idea that the parties talk, see if they can work something out before seeing the judge. If you do come to an agreement, this is what we call a settlement. Most judges are going to encourage settlements between the parties. and many provide resources to facilitate settlements, such as standard forms or allowing mediators to basically help the parties craft something. It's really important to note that settlement agreements require both parties to agree to specific terms. The parties, though, determine what those terms are. A good agreement is going to clearly define some things. So, for instance, if one party is looking to move out in exchange for a dismissal, the agreement needs to be specific about when they're moving out, what happens if they do move out, and what happens if they don't move out. If you're talking about agreement for a payment plan, you're going to want to include information about what's owed, how the payments are broken up, when the payments are due, what happens when the tenant comes current, and what happens if the tenant doesn't come current. As I mentioned, the courts have standard agreements in many cases. You want to review those before signing them, make sure that they actually reflect what the parties negotiated. I've seen too many cases where the parties appear to negotiate a payment plan, but the agreement itself from the court contains language requiring the tenant to vacate in addition to making the payments. And so, you want to be super sure that the document that you're creating reflects the agreement made by the parties. The settlement itself has to be in writing, has to be signed by both parties, and needs to be filed with the court. Oral agreements, informal agreements, unwritten agreements, those are not enforceable by the court. Keep in mind, too, the agreement always involves parties giving up rights and may impose penalties on parties if they fail to comply with the agreement. So if you are in the process of negotiating, you want to make sure that you are only agreeing to things that you can do and that you're not agreeing to anything you cannot do. So to sort of recap the process so far, there's been notice to vacate. The tenant didn't vacate. An eviction has been filed. You've gone to court in justice court. You haven't settled the case. The judge issues a judgment. What happens next if you disagree with that? The code allows what we call a de novo appeal, which basically means the case is heard from the beginning in a higher court, in this case, county court. In order to exercise your right to an appeal, you're required to do one of two things. First, you can pay something called an appeal bond. If you're a landlord, you're probably going to be stuck paying that bond. If you're a tenant, you may not be able to pay that bond, which is normally set at 2 months of rent. In order to have that bond waived, you need to file something called a statement of inability to afford court costs instead. And that is sort of the most common form used to appeal these sorts of cases. Those forms are provided either at the clerk's office or you can get them online. Basically, they're asking about what your income is. You have to provide information about your assets, any debts you have, and you're signing under oath and pleading to the court that you can't afford to pay that appeal bond. That form is due within 5 days of the judgment. If you do not appeal within those 5 days, the writ of possession can be issued against you and you waive your right to appeal. Those statements can be challenged by either party or by the judge. If your SOI is challenged, you should look to talk to a lawyer. They can provide you additional information about, defending that process. And then if you go to court and the judge denies the SOI, so in other words, says that you have to pay the appeal bond, and you disagree, there is a process to appeal that decision. But I would recommend talking to a lawyer if you're dealing with that, because those timelines are very tight, and it can be difficult to effectively appeal the SOI. So you filed the SOI. It hasn't been challenged. Within 5 days of filing that form, if you're being evicted for non-payment of rent, you have to make a payment of 1 month of rent to the court registry in order to retain possession of the property. If you're appealing but you don't intend to stay past those 5 days, you don't need to worry about making those payments because those payments are basically to secure possession of the property. But if you do intend to stay past those 5 days, you do need to make that payment. Important to note, registry payments are basically to pay for the current rent, not for the past rent. So for instance, if you're being evicted this month and judge just issued a judgment against you and you appeal and you're required to pay rent before the end of September, that payment pays for September rent. You'll then need to make sure that you remain current as the appeal process continues. So if you make the initial deposit in September, you'll then need to make another payment of 1 month of rent at the beginning of October to remain current. But you don't need to worry about the past due rent in order to retain possession. Once the appeal itself has been filed and the court has dealt with any SOI issues or with the registry payments, the case gets transferred to county court at law. It's then assigned to a court. You should receive paperwork in the mail as to what the assignment is and when the hearing date is going to be. So you want to make sure you check the mail regularly. The forms ask you to file an answer. If you've appealed with the SOI answer, the SOI form, that counts as an answer for some parts of this process. And so you don't necessarily need to file an answer immediately. But our recommendation would be to file at least what we call a general denial at some point during this process. And those forms are available online. So now we get to county court and that trial. As I mentioned, county court, the case is heard de novo, so from the beginning. Anything that happened in justice court doesn't matter. It's basically a fresh lawsuit at that point. It's important to note that county court at law is very different from justice court in terms of procedures that are used. The procedures are uniform between the courts, and they actually do have to apply the rules of evidence because it's a court of record. And so your experience in one county court is likely to be similar to your experiences in a different county court. As I mentioned, there's no need to talk about what happened in justice of the peace court. Landlord has to prove up their case all over again. So, you should pay attention to whether they filed the evidence again, what the testimony shows, whether the person who's testifying actually has knowledge about what they're talking about. And all of those can form bases for defending the case. Keep in mind, the landlord also has to prove up the case with both testimony and evidence, whereas in justice court, their testimony might be enough to basically win them the case. Judges have to balance the need to allow pro se parties, so parties who are unrepresented, to participate fully. They also have to make sure the procedural rules are followed. So just be aware, the court is sort of engaged in a balancing act if you're in county court. And because the process is so specific, if you haven't talked to an attorney before the appeal, you should definitely talk to an attorney while this is going up if you can. So let's say that you get to county court and you lose. The court requires 10 days to pay an appeal bond if you intend to appeal up to the Court of Appeals. We generally don't deal with that because the Court of Appeals, unlike the proceeding in county court, isn't de novo. And so they're going to be looking for specific errors. Normally, the courts do a pretty good job about avoiding error that would allow them to reverse a decision on appeal. But also, there's a specific process by which you preserve error. So if you're thinking about appealing up to the Court of Appeals, if you don't have an attorney, you're probably not going to be successful. That said, though, the court does have to provide you the time to pay the appeal bond, though. So normally the court will schedule a writ date 10 days after judgment. Keep in mind, too, we've talked about the payments to the registry, both the initial deposit and subsequent payments. The courts here often will allow a landlord to file something called a sworn motion for default. If that's filed, they can either seek possession of the property early through a special default hearing, or if this does go to trial, the court may entertain a motion for immediate possession. So just be aware, in order to basically be guaranteed the 10 days after trial, you have to make sure that you're current on registry payments. Wanted to briefly talk about some special cases you might see during this process dealing with public housing and subsidized housing issues. As I've mentioned, if you're on public housing or subsidized housing, oftentimes you have special lease addendums, such as the HAP contract. That's going to spell out whether there are special protections or specific protections for a tenant against eviction, or whether there are specific processes that the landlord needs to follow. Some of these protections include limitations on reasons they can terminate the lease. It might require a period to respond to allegations if there's an informal hearing requirement to contest a termination. And if you're in public housing or on subsidized housing, usually those are going to be properties covered by the CARES Act. And so usually there's a 30-day notice requirement if it's a non-payment of rent case. I don't want to go too far down this because these programs differ from program to program. So Section 8 housing choice voucher rules are going to be different from, for instance, the low-income housing tax credit rules. So if you are on public housing or living in subsidized housing, review the addendums, review the lease. If you need assistance, reach out to an attorney. And if you're a landlord dealing with any of these, keep in mind there are likely going to be additional requirements that you need to follow in order to successfully and lawfully evict a tenant. Real briefly, the worst case scenario in an eviction suit for a tenant is going to be the writ of possession being issued. It's also not a great outcome for landlords because it means going through the process without some form of resolution prior to a judgment. But we've been getting questions on what to expect if there's a writ of possession issued. First of all, just so you're aware, writ of possession, that's the legal term for the document that allows the constable to remove you from the unit. Prevailing plaintiff must possess the writ of possession in order to actually remove the tenant. Just getting a judgment isn't enough for them to remove a tenant, and they're not allowed to engage in self-help. The timeline on when to request a writ largely depends on what happened at court. So, for instance, we've talked about the 5 days to file the appeal in justice court. The landlord cannot request a writ of possession until the 6th day. Same thing in county court. If the court has to give 10 days for the tenant to file the appeal bond, then the landlord has to wait until day 11. Once the writ is requested, it gets sent to the judge. The judge then signs off on it, transmits it to the constable's office. The constable then has to serve the writ, wait 24 hours, and only then can they actually execute the writ. Many constables provide information to the tenant and try to coordinate with the tenant to avoid having to actually go through the process of forcibly executing the writ. A lot of constables, they rather just not deal with anybody there and give the tenant the ability to leave on their own. And, given the timelines involved here, and I should mention, the shortest timeline for a writ would be the writ is requested, immediately gets transmitted to the constable's office, served that day, wait 24 hours, and then executed. You're talking about the shortest time being probably about 3 days. In reality, you're talking about more likely a week to 2 weeks. And so what we've seen is some constables will post the writ like a week before they intend to execute, but it gives the tenant the ability to sort of move out during that time rather than having the constable execute the writ, need to remove and arrest them immediately. So once the constable does have to execute the writ, they remove the tenant, they change the locks, and the tenant's property is removed from the unit. Sort of some trivia, but important to note, writ may not be executed if it's raining per the code. So that kind of covers the eviction part of this presentation. We did want to talk briefly about some other things that we see, which is sort of might call self-help. In some cases, a landlord, rather than going through the process of an eviction, will decide to simply lock out the tenant, or they may engage in a lockout for a different reason. Landlord can't exclude tenants from their home unless there are repairs being made, unless there are moving contents abandoned by the tenant. There is a part of the code that does allow for locks to be changed if they provide notice and if they provide access to the unit and a new key within a certain period of time after the change of the locks. And then we say judicial process allows, that just refers to the eviction process. We also see sometimes landlords will try to force out a tenant by shutting off their utilities. Again, landlords cannot intentionally interrupt utility service unless it's for repairs, construction, or emergency, or unless shut off is allowed under the property code and all requirements are strictly followed. I'm going to sound a little bit like a broken record for the next few slides because these processes are extremely similar. They're slightly different from self-help. So just in general, self-help is not allowed. What happens if you're a tenant and you do run into this issue? In both cases, whether there's a lockout or utility shut off, if the landlord does not follow the code and engages in self-help, you can file a lawsuit against them. When this is a lockout, we call this a writ of reentry. When it's a utility shut off, we call it a writ of restoration. You can bring either of these lawsuits even if you're behind on rent payments. We'll go briefly into the process, but these are lawsuits. They're filed in the justice court in the precinct you live. There's a filing fee associated with them, but those can be waived by filing a statement of inability to afford court costs. If you also, as a practice tip, if you end up in a situation where you're looking at one of these, from the beginning of when you think that your landlord may have acted unlawfully, you want to document the lockout, the interruption, and document any expenses that you incur because of the lockout or the utility interruption. So when you've been locked out, per the code, if you've been locked out, the landlord has to, within 2 hours of request, provide you a new key. If they do not do that, you can file the writ of reentry lawsuit. You fill out a petition. Those are available online or at the clerk's office. Attorney can also help you with that. Basically, you're stating the facts of the case and you're swearing under oath that they're true. Once you file that suit, you get set for an ex parte hearing, which basically means that you're not required to serve your landlord prior to the hearing, although we generally recommend that you do put them on notice you're having the hearing. At the hearing, you tell the judge the story. If the judge agrees you're illegally locked out, they'll sign off on a writ of reentry ordering the landlord to let you back in the home. That writ is then served by the constable on the landlord, who then by law has to let you back in. If you're damaged through this process, you can bring a separate lawsuit, and we generally recommend bringing a separate lawsuit to seek damages. Damages include 1 month's rent, $1,000, actual damages or expenses, court costs, and reasonable attorney's fees, minus any delinquent rent or other sums. So, you're talking about if your landlord locks you out, it's potential that you could collect on some damages there. The code also provides an option to terminate the lease if you've been locked out. Utilities, the process is very, very similar. If services have been disconnected illegally, you file the writ of restoration lawsuit in the precinct. Petition, again, you're attesting to the facts and signing off that you, under oath, that the facts are true. You get set for an ex parte hearing. If the judge agrees that the utilities were disconnected illegally, you get a writ of restoration ordering the landlord to restore the utilities, which is then served on the landlord. They have to restore the utilities, and then you can also bring a separate lawsuit for damages. And again, those damages are extremely similar to what you saw in a writ of reentry lawsuit. Finally, we get a lot of questions concerning security deposits and what to expect if you're moving out in an eviction and what happens with the security deposit. We also separately get a lot of questions about what happens if you're moving out even without an eviction and your landlord might retain the security deposit. So it's a separate issue from the eviction or repair remedy or anything else. Landlord is allowed to keep and deduct from security deposit any amounts owed for damages to the property, charges which the tenant may be legally liable, so for instance, back rent. They're not allowed to charge for things like normal wear and tear of the unit, though. If you're moving out and you think there might be a security deposit issue, the best practice is to schedule a walkthrough prior to surrendering the property. That gives you an opportunity to document any issues which could affect where your landlord is able to keep part of the security deposit. And then if there are no damages, you could document that you didn't find any damages as part of the walkthrough in case the landlord later attempts to add additional deductions. Assuming there's no reason for the landlord to retain all of the deposit, the landlord does have an obligation to refund in whole or in part the security deposit on or before the 30th day after the tenant surrenders the unit. That timeline's a little misleading because you do need to provide the landlord a forwarding address in order to start that timeline. If they do intend, however, to keep part or whole security deposit, they are generally required to send you a written description and itemized list of deductions. So just be aware, even if you expect them to take some of the deposit, they do need to provide you that list documenting what they've deducted. If for some reason you are entitled to getting security deposit back and they don't refund it timely, our recommendation would be to send a demand letter via certified mail and to contact an attorney. There are specific damages associated with wrongfully withholding a security deposit, and the failure to provide that accounting lead to some presumptions that the deposit's been withheld in bad faith. So just be aware, talk to a lawyer, but you would have rights if you believe your landlord is wrongfully withholding a security deposit. That basically brings us to the end of the presentation. Some brief additional tips. Before you go through any legal process or risk having to deal with being a defendant in the legal process, it's usually best to get ahead of the problem. Talk to your landlord as soon as an issue arises. If your landlord listens to your tenant, if they ask for repairs. Rental assistance may still be available. We do know that 211 has had some funds, although those are dwindling. There are always independent groups or charities that may have funds available. So if you're a tenant and you're dealing with the possibility of falling behind, we recommend checking with local organizations, see if they'll cover anything. And then finally, if you're having issues with the condition of the unit, pay your rent and then contact somebody for help getting repairs. And that is it for me. I'm ready for questions. If you want to apply for services, we have the contact information here. You can apply online on our website or call either of those numbers to put in an application. Okay.
Sorry about that. I was trying to go
I've
through.
already, I lost you guys for a second.
No, 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 no. Sorry. There was a question here in the chat. Are landlords required to rent to tenants with an emotional support animal if the property is advertised as no pets? That was one of the questions that got emailed to me too.
Um, I don't know those requirements off the top of my head. Generally, emotional support animals are treated differently than pets. So, for instance, you're not allowed to charge a pet deposit. Um, I do think that there are some requirements under the ADA, for instance, for service animals to be allowed, but I don't know those terms off the top of my head. So,
And for the ADA requirements, what do you, because everybody's now got an emotional support animal. Is there a limitation even still on the kind of emotional support animal that you could allow? Like if it's a really large
I
pet
mean,
or
I believe there are reasonability requirements. For instance, you obviously, if you're a landlord and you have someone with a service animal, under the ADA, for instance, you don't have to host a horse in an SRO.
I was going to ask about a
Um,
pig because I knew somebody that had an emotional support pig.
yeah,
So just
yeah. It's been a while since I've seen one of those, so I wish I had more information for you off the top of my head. But I said there is a reasonability requirement, but you know. ADA would likely control if it's a service animal. And then I know support animals are treated differently under the code, but I don't know those rules specifically.
um,
That may be one to apply for services if you're dealing with an issue.
um, I remember you asking or mentioned or got on the topic about security deposits. Are are tenant are landlords now, well, not now, but I've gotten the question about landlords requiring you to pay for security before you are actually even eligible or apply for a particular unit. Can they make it a requirement that you pay the security deposit up front before you even get approved?
Um, that sends up red flags for me. I don't know that there's anything specifically prohibiting that. I'd have serious questions about what the property is doing before I would pay that, though. The key thing, though, if it is a security deposit, it's refundable. Like that's the key thing, is that you're entitled to that money back. It's not an application fee. It's not a yeah,
That
I don't know if I've
that's
seen
another
that specific fact pattern. Like I said, I'd have questions and I don't want to throw any allegations out, but sometimes there are people who run scams and want to get money and
that
um
was another thing about the security deposit about it being refundable. I've had a couple of property managers to tell me that that it's stipulated that if there's something that's false, if somebody lies about a criminal record or lies about some information on the application, and it turns out that it's actually true, that they are not refunding security deposits.
I don't know that there's any specific case law on this issue. Generally speaking, like I said, the point of a security deposit is to sort of cover the damages to the property. I have seen like some lease agreements that say any breach of the lease surrenders the deposit. It's arguable that that could be an impermissible, we call liquidated damages. But I think that is one that I would look to case law. And if there's no case law, I think it's probably only a matter of time before one of those cases gets tried, where somebody challenges the withholding of a deposit because of a breach of the lease. But again,
Okay.
I haven't done a case law review on that. I'd imagine that there's an answer to that there.
Okay. This is the other thing I wanted to have a question. I had a question about the timeline from the time an eviction happens to the time um, the writ is served and somebody actually has to leave. Realistically, what is the time frame from of what what a typical eviction process is supposed to be from the time they receive notice to vacate to that end of that time frame? Do they have before they are actually put out, basically?
So let's do sort of a standard one, go step by step. So you have regular housing, there's no subsidized housing, no Freddie Mac, Fannie Mae. Tenant gets a 3-day notice. They don't leave. On the fourth day, the landlord can file the eviction suit.
Okay.
So let's just say that they file, notice is delivered on Monday, deadline to leave by Wednesday. They can file on Thursday. The court gets the petition. They have to set a date. They have to serve everyone. You're talking, I think, on a trial setting about 2 to 3 weeks out from that. And
Okay.
Brad, this is back in the napkin math. Some of these things can vary. We had one court in this county where the consul was so backed up a few years ago that they would set things timely, but because the tenant couldn't be served, things had to kept getting pushed back. But you're talking about probably, let's say, 3 weeks. So you go to trial, the uh, the judge hears the case, decides in favor of the landlord. Tenant's entitled to 5 days to file their appeal. Um, Realistically, that's normally roll over to the next week. So you're talking about Monday, Tuesday deadline to file the appeal. But you're talking about basically between when the notice to vacate is delivered and when the first opportunity for the landlord to get the writ is usually about 4 to 5 weeks. Back in the
Okay.
napkin math.
Okay. I'm
If
just trying
the
to give people a picture
Yeah,
of what that actually looks like.
yeah. If the tenant appeals, we're usually seeing settings about a month out from when the initial judgment is, and then 10 days. So you're talking about that's what, a little bit over 2 months at the longest deadline. If everything's done correctly, it's not dismissed. So
So
that's you know, so that's sort of what we've been seeing is about 2 months.
okay, that's a long time. Wow.
It's a lot faster than you'd think. Um, but that's sort of how the timeline works. The county courts used to be really backed up. They've shortened that timeline up significantly. I can say that the new law is going to provide new deadlines for things. I don't think it'll actually shorten anything significantly. And there may be some issues as far as scheduling is concerned, but it will make things a bit more uniform. So, we can talk
And,
about that in the future when we have eyes on the new rules of civil procedure.
and you said that's supposed to take effect for the first of the year?
Yes.
Okay. All right. Let me see. Another question that I had here. Um, if my leasing office changed my lease agreement slash papers, also forged my signatures during a time period where there was no office manager, what are the rights of the tenant in that regards?
Um, I mean, the first thing I would do is actually contact an attorney. I think that there may be specific issues that you want advice on. Um, if you believe a crime's been committed, obviously contact the police or the DA's office and report it to them. But as far as getting advice on your rights in that situation, I would I'd say you're better off talking to an attorney and getting specific information than getting sort of general information on that.
Okay. I'm checking our social media page just to make sure I don't have any questions here or comments. For the participants that we've got that are joining us, are there any questions that you all have? Um, while you got an expert here on the line for you. If you guys have any questions, speak now or forever hold your peace.
Until next month, and then you'll get somebody else.
Yeah, we like to make sure that we, again, make sure we have the experts to come in to provide the most up-to-date information, because as you were saying, the new rules or new laws take effect for the first of the year. We can't keep up with all of those things. So we want to make sure that the legal experts that have the knowledge and the information about those kinds of changes is what's being provided for you all. We know that there are a lot of people that are out there on these different social media platforms that are putting a lot of information out there as it relates to evictions or foreclosures or what have you that is not relative to the laws for the state of Texas. So do know that, please do your due diligence, trust your sources of where you receive your information, and make sure that it's from somebody that is versed with the laws as it relates to evictions and tenant rights in the state of Texas. So um, there's a lot of misinformation out there. There's a lot of scam companies that are out there. They'll pay us and we can do this for you or help against you, for this, that, and the other. But, do your due diligence and make sure that you are trusting a reliable source like us. So let's see. There are no other questions here. I believe that's all we've got here for you folks. With that being said, thank you very much, Mr. Daly, for taking the time out. I know you guys are bombarded at this point with eviction cases. It is getting to be unfortunate that this is going on, but it's more and more eviction cases that are being presented. More than a lot of folks really think. So do know that there are um, there are a few different companies or organizations that are out there based on availability, based on the amount of their funding that are helping with rental assistance for folks, but they are not out in the masses like they used to be. Funding sources have gotten extremely scarce. Um, with assistance as it relates to rental payments and utilities and things of that nature. So you just have to kind of continuously be on the lookout if you guys are in any kind of need in for rental assistance or for utility services. If you guys are aware of any, we try to keep a resource list here that we can provide to the community. If you could please let us know, stick it in the chat so that somebody else may know where they can go for rental assistance or if they're in need of some type of uh, resource or service. So we'd be happy to take that information on and try to share it with as many community members as we possibly can. So unfortunately, there are just so many other people that are in need that the resources are not available. So I want to thank you all for joining us this afternoon. As Benjamin stated, you are welcome to come back. We are here the third Tuesday of each month with the eviction presentation. So if you have questions later on, or someone else may have some information or questions that they may want to ask next time, then you do have the opportunity to come back and join us for that. What we got coming up on Wednesday? I'm sorry, on Thursday, we are hosting a presentation called Money Over Matter, or Mind Over Money. Sorry, I'm trying to find my flyer. It's called Mind Over Money, How Finances Shape Your Mental Wellness. We're hosting that in conjunction with Family Houston at their office over on Durham Drive on Thursday from 5 to 7 p.m. Food will be provided. It's some information, the presentation to help explore the powerful connection between money and mental health, highlights on how financial stress impacts your emotional well-being and your overall quality of life. A lot of folks don't realize that a lot of these things are all kind of related together. When you're stressed out and creating anxiety and whatnot over your finances, all of that kinds of has a toll or takes an impact on your physical health as well. For people that are facing evictions, when they're mentally stressed out and going through anxiety, going through depression, it impacts how they actually show up to work or for work, which could potentially impact your job, and then it becomes a little cycle. So it's going to be a lot of information that's going to be provided at that presentation. It's going to be live and on Zoom. So you do have the opportunity to watch if you're not able to make it in person as well. But we definitely encourage many folks to come out to get some information and resources as it relates to finances and your mental health. So thank y'all very much for joining us again. We welcome you back anytime. Feel free to reach out to us if you have any questions. And again, we do encourage you to reach out to our legal service partners if you find yourself in need of any civil legal assistance. You all have a wonderful remainder of your day. You all take care of yourselves, stay safe, and we will see y'all next time. Thank you very much, Benjamin.
Thank you for having me.
All right.